Meeting to order. This is now meeting number 10 of the House of Commons Standing Committee on Justice and Human Rights. For our first panel, we have with us Mr. and Mrs. Best, Ronald and Michelle, from the Brantford Police Association, Jeremy Morton, the President, and from the London Abused Women's Centre, Jennifer Dunn, the Executive Director by video conference, and from the Police Association of Ontario, Mark Baxter. Je tiendrai à rappeler aux témoins qu'ils ont.
Let me remind the witnesses, Mr. and Mrs. Best, you have 5 minutes total. Mr. Morton, Ms. Dunn, Mr. Baxter, you have 5 minutes each, and after that, we will proceed with rotation for members of the committees to ask their questions. Without further ado, I will give the floor to Mr. and Mrs. Best.
And then I'll proceed with Mr. Morton, Ms. Dunn, and Mr. Baxter, 5 minutes each. Thank you and welcome.
Good afternoon, and thank you for allowing us to share our story of our beautiful daughter, Kelly. My name is Michelle, and my husband, Ron, is beside me, and we are here today as grieving parents. At 28 years old, Kelly had built a full and beautiful life. She was a daughter, a sister, an aunt, a granddaughter, a fiancé, and a friend to many. She and her fiancé, Travis, were planning their dream wedding for this June. We were supposed to watch her walk down the aisle. On January 15th, our world stopped. Kelly was killed that day. We were on our way to meet her to prepare for her grandfather's funeral, who had passed just 48 hours earlier. Her fiancé, Travis, and I got the call from the RCMP asking us to meet them. As we drove there, I called my husband and my son, our son Michael. When we arrived, the RCMP told us the complete unthinkable, that our daughter was gone. Over the next few days, we learned that the man who killed her had a warrant for his arrest issued at the time of the incident. He had breached bail conditions for previous crimes involving drugs and theft. That morning, he had stolen a truck, driven it towards Port-au-Prairie, and caused a crash that killed my daughter. After the collision, he kicked out the truck's window and fled on foot. When he was caught, he had a large amount of methamphetamine in his system. He was taken into custody, appeared before a judge, and unbelievably was later granted bail, again. Despite killing our daughter while out on a warrant, the system decided to give him yet another chance. We attended the bail hearing along with our MLA and Mayor of Port-au-Prairie and family members. The judge ruled that he could be released to a behavioral health unit in Winnipeg, Manitoba, once a bed became available. He was ordered not to drive, not to use drugs, and to follow the law. When the spot became available, he was transferred to that facility. We believe within hours, he had escaped again. To this day, we do not know how long he was in that facility. When we found this out, my stomach sank with the same sick feeling I had the day Kelly was killed. My greatest fear was that he would hurt someone else or flee. And why wouldn't he? That behavior was entirely predictable. The judge had assured us that if he breached bail again, a warrant would be issued immediately. But there was already a warrant out for his arrest when he killed my daughter. What good are these reassurances? They mean nothing. This man was granted bail 3 times in 2 weeks before Christmas 2024. On New Year's Eve, he breached his conditions again, and a warrant was issued. In 14 days before he killed my daughter, he stood before a judge 3 times. 3 times he was given bail. 3 times he walked away. Why does someone who shows no respect for the law, the police, the judges, or for society keep getting another chance? We hear a lot these days about rights, constitutional rights, individual rights, the rights of the accused. But what about our rights? What we do know is that what we're doing right now is not working, and we need change. The definition of insanity is to continue to do the same things in the same manner, repeatedly, and expect a different outcome. In my view, this is where we are at in the criminal justice system. What about Kelly's right to safety? What about our right to live in a country where the laws protect the innocent, contributing people to our society? Who's defending those rights when repeated offenders are released again and again, only to reoffend, sometimes within hours? Our communities are in crisis. Our justice system is broken. And somewhere along the way, we've started to accept this as normal. It's not normal, and it's not acceptable. If you hear anything from me today, hear this. The cost of these failures is measured in lives, in grief, in trauma, and in fear of repeated criminals on our streets. As a mother, as a Canadian, I expect better from my government. I expect that you will fix a system that keeps putting dangerous people back on our streets. We need you all to do the hard work, fix our broken system. It's your job, and it's what we expect. Thank you for having us.
Thank you, Ms. Best. Mr. Best, do you want to, we have a minute or so, perhaps a little more if you want to say a few words.
No, I think that we can cover it in the questions that we take. I think that's fine. Thanks, Mark.
Thank you. Mr. Morton, up to you.
Mr. Chair, members of the committee, good afternoon, and thank you for the opportunity to appear before you today. My name is Jeremy Morton, and I serve as president of the Brantford Police Association, representing 330 frontline police officers and civilian personnel who work proudly to serve the citizens of Brantford, Ontario. I also want to acknowledge that I appear here as part of the broader Canadian Police Association, which represents more than 60,000 frontline police personnel across the country. From large urban centres to small and mid-sized communities like mine, police associations are united in supporting meaningful, practical bail reform that addresses the ongoing challenges posed by serious, violent, repeat offenders. The introduction of Bill C-14 last week by Minister of Justice Sean Fraser represents an important and welcome step in that direction. As CPA President Tom Stamatakis has said, this legislation responds to long-standing calls from police associations across Canada to strengthen public safety and ensure that individuals who repeatedly commit violent offences face appropriate consequences. We appreciate that the government has listened to these concerns and taken action. In Brantford, as in many parts of Canada, our officers routinely arrest the same individuals multiple times in a single year. Those arrests are made professionally, reports are completed, and cases are brought before the court. Yet far too often, these same offenders are released almost immediately without sufficient supervision or consequences for breaching their conditions. This revolving door of arrest and release drains police resources, frustrates victims, and erodes public confidence in the justice system. That loss of confidence is not theoretical. It's something we hear directly from residents and business owners who are tired of seeing the same individuals reoffending in their neighborhoods. It also affects the morale of officers that take pride in their work and want to know that the system they serve is fair, effective, and accountable. Bill C-14 proposes targeted measures that will help address these issues, including strengthening bail provisions for repeat violent offenders and assuring that community safety is a central consideration in release decisions. These are practical, evidence-based reforms that can make a real difference in keeping our communities safe. Of course, no piece of legislation will solve every problem on its own. Implementation will matter. And continued investments in police services, Crown attorneys, and correctional personnel will be essential in making these changes effective. But Bill C-14 is a significant and positive start. Finally, I want to emphasize that public safety should never be a partisan issue. Canadians expect their elected representatives to work together to find common sense solutions that protect communities and respect the rights of all. Police associations across Canada are encouraging to see these legislations introduced, and we urge Parliament to move quickly and collaboratively to ensure these measures are passed into effect as soon as possible. Mr. Chair, our members are doing their jobs. They're arresting dangerous offenders and bringing them before the courts. We are asking that the justice system now do its part and ensure those efforts have lasting impact. Thank you for the opportunity to appear before you today. I look forward to your questions.
Ms. Dunn, over to you, 5 minutes.
Thank you, Mr. Chair. I just want to first address Mr. and Mrs. Best and say that I'm so sorry for the loss of your daughter. My name is Jennifer Dunn, and I am the Executive Director at the London Abused Women's Centre here in London, Ontario. The London Abused Women's Centre is a non-residential centre and provides women and girls over the age of 12 who have been subjected to abuse by an intimate partner, assault, harassment, exploitation, trafficking, and non-state torture with immediate access to long-term trauma-informed counselling, advocacy, and support. For more than 42 years in London, Ontario, our organization has supported women and girls who have been subjected to male violence, and every day we see how decisions made within Canada's justice system shape women's safety and their faith in the system itself. Today, I speak on behalf of survivors, their families, and frontline workers who stand beside them. Bail and sentencing decisions are not abstract legal matters. For some women, they are life or death moments. My first point is that bail must be trauma and violence informed. When a violent offender is released, survivors are often forced to relocate, leave work, or lose their job, or live in hiding. These are not just disruptions, they are losses of safety, identity, and stability. Bail decisions must reflect an understanding that violence is rarely a single act. It is usually a pattern that continues even after charges are laid. A trauma and violence-informed approach means recognizing that history and centering the victim's safety in every decision. This does not mean denying bail in every case. It means assessing risk with depth and compassion and asking, what will this decision mean not only for the survivor's safety, but potentially her life tonight, tomorrow, the next month, and could be over the next couple of years, depending on how long this particular court case takes to get to trial. My second point is to highlight Caitlin Jennings' story. In London, we remember Caitlin Jennings, a young woman whose life was taken in an act of femicide. Her case is a painful reminder of what can happen when the system fails to protect, but also of what happens when it works. The man charged with Caitlin's death had a bail hearing on November 2023, and he was denied bail. Superior Court Justice Leach denied bail after reading a 2-hour decision. Colleagues and I sat in that courtroom supporting Caitlin's family, and we were relieved to know that he would be held in custody until his trial. And while that did not erase the tragedy of her loss, it gave her family and other survivors a measure of reassurance that the justice system could prioritize safety when the risk was clear. Caitlin's father said, "This is one step in healing and justice for Caitlin." Now, his trial isn't until September 2027, but I could honestly not imagine this man out of custody for the next 2 years, knowing what I know. Caitlin's story reminds us that decisions around bail should not only be procedural, because behind every court file is a woman, a family, and a community living with the consequences. My third point is that systems must work together and be equally funded. Meaningful reform cannot happen in isolation. The justice system, police, and community support must be aligned and funded equally. At present, the imbalance is stark. The criminal justice system receives the bulk of the investment, while frontline social services are left to fundraise for survival. Yet it is those services such as counseling, safety planning, housing, and advocacy that help survivors stay alive long enough to see justice happen. Without stable funding for social support, bail reform will remain a theory on paper. Safety depends on collaboration, not competition, between systems. My fourth point is accountability and the role of sureties. Accountability is essential when bail is granted. Too often, high-risk offenders are released into the care of sureties who do not understand, cannot enforce their responsibilities. At the London Abused Women's Centre, we worked with a woman whose perpetrator was released on bail, with his mother as the surety. She had no control over his actions. She knew he breached conditions, and she did not report it. There were no consequences, and the victim's fear returned immediately. She could not leave her home without a safety plan. She couldn't even access our services without a safety plan. Sureties must receive clear information, training, and oversight, and there must be consequences for knowingly ignoring breaches. My fifth point is around balancing safety and fairness. The London Abused Women Centre is not necessarily advocating for mass incarceration. Overly punitive systems harm those who are already the most vulnerable, particularly Indigenous and racialized individuals. But what we would like to call for is targeted accountability. High-risk, repeated violent offenders must face detention. But justice reform must also include investment in prevention, education, trauma support, addiction support, and the list goes on, through a trauma and violence-informed lens that stops violence before it starts. Safety and fairness are not competing values. They must coexist for justice to have legitimacy. In closing, every woman deserves to live free from violence. Every child deserves to sleep safely at night. And every system from the courtroom to the counseling office shares that responsibility. Reforming bail and sentencing is an opportunity to build a justice system that is trauma-informed, violence-informed, and survivor-centered. It is an opportunity to ensure that when we ask, will this decision keep victims and communities safe? The answer is yes. Thank you.
Thank you, Ms. Dunn. Over to you, Mr. Baxter.
Thank you, Mr. Chair and members of the committee. Just as I begin, Mr. and Mrs. Best, I would just like to commend you for your courage and the strength that you've shown in the face of the unimaginable loss of your daughter, Kelly. And my sincere condolences to you and to your family and to all those families who have been impacted as a result of violence committed by repeat and violent offenders. I want to thank you for the opportunity to appear here today on behalf of the Police Association of Ontario, representing more than 32,000 uniform and civilian police personnel from 46 police associations right across the province, including the Brantford Police Association. Our members are the dedicated men and women who serve on the front lines, keeping our communities safe every single day. Today, I'm here to address challenges that threaten public safety, our current bail system. As it stands, bail practices often allow violent and repeat offenders to be released back to the very neighborhoods that they have harmed, undermining public confidence and draining police resources. This is more than a procedural flaw. It is a cycle that emboldens offenders, increases community risk, and perpetrates a dangerous pattern of apprehension, release, and reoffending. The frustration our members feel is echoed by the communities they serve. To many, the justice system has become more than a revolving door. It feels as though the door has been left wide open. Recent data is cause for concern. Between 2019 and 2023, violent criminal code violations in Ontario increased by 20%. Nearly half of convicted offenders reoffend within 3 years, and violent repeat offenses are on the rise. These numbers, combined with firsthand accounts from our members and victims, underscore the anxiety and the frustration felt by Ontarians and the immense challenges facing those sworn to protect them. The Police Association of Ontario has long advocated for practical, charter-compliant bail reform. We have called for evidence-based changes, such as expanding the list of reverse onus offences to include violent auto theft, home invasions, human trafficking, and more, lengthening the review period for prior convictions, and ensuring that courts rigorously scrutinize bail plans before release. These are not abstract proposals. They are grounded in the realities our members and community members face every day. Both major political parties have recognized the urgency of bail reform. Public safety is not a partisan issue. Well-designed bail reform that balances charter rights with community protection is in everyone's interest. The introduction of Bill C-14, the Bail and Sentencing Reform Act, introduced last Thursday, October the 23rd, marks a significant and long-awaited step forward. The bill addresses urgent shortcomings in our bail system. Its provisions, including new reverse onus rules for violent and organized crime, stronger bail conditions, and tougher sentencing for repeat violent offenders, respond directly to concerns raised by our members for years. This is an encouraging sign that the voices of frontline officers and the communities we serve are finally being heard at the highest level. These proposed reforms reflect the lived realities of our members, the experiences of victims, and the expectations of the public, and send a clear message that repeat and violent offending will not be tolerated in Ontario or across Canada. Let me be clear. Without meaningful change, the safety of our communities and the lives of police officers and the public remain at an unacceptable risk. Each release of a violent offender increases risk of tragedy in our communities. Ontario cannot wait for more lives to be put in jeopardy. Decisive action is needed now. We urge all parties to pass Bill C-14 immediately. Every day that this vital legislation is used as a political bargaining chip or a soundbite during question period leaves real lives on the line. Mothers, daughters, fathers, sons, sisters, brothers, friends, and families across Ontario deserve action, not politics. On behalf of the 46 police associations that we very proudly represent, I thank the Government of Canada for taking concrete steps to strengthen public safety and support those who work every day to protect it. Ontario's police personnel will continue to do our part in our communities, in the courts, and on the front lines to keep people safe. We look forward to working together to ensure that these reforms are implemented effectively and deliver the results that Ontarians and Canadians expect and deserve. Together we can and we must build safer communities and ensure that these reforms deliver a justice system that protects victims, not offenders. Thank you.
Thank you. We'll get a chance to go through probably 2 complete rounds, starting off with Mr. Brock for 6 minutes, Ms. Latanzio for 6, and ensuite Réal pour 6 minutes à son tour, suivi par Monsieur.
Mr. Lutton, in the second round, 5 minutes. Mr. Chang, Fortin, Leslie, Chang, 5 minutes each, except for Mr. Fortin, 2.5 minutes, as agreed. So I'll give the floor to Mr. Brock now. 6 minutes.
Thank you, Chair, and welcome to all of our witnesses. Thank you for participating. To Mr. and Mrs. Best, I am heartbroken, I am angry, and I am disgusted that I was once a member of a justice system that has failed you so miserably. I guess to really emphasize that point, every time that offender who took your daughter's life appeared in front of a judge and was granted bail, he promised to follow those conditions. And if he was released with a surety, that surety also promised that he would abide by those conditions. These are false promises that are given every single day in this country, and the justice system accepts it at face value, will often sometimes give warnings. Should you breach these conditions, you ought not to expect to be released a second time or a third time or a fourth time. And history and example after example shows us that these are promises that are not fulfilled and consequences not given to offenders. So if you could say to the government, what is the most important thing to you as survivors of a loss such as what you've suffered? What would be the most important thing that you could tell this committee when we write our report to the House?
It would be nice to have the criminals become accountable, no different than we're accountable as members of society. We sat in on a bail hearing, and the accused sat in a small cubicle in the detention facility, and it was like, geez, are we done yet? Like he's not engaged, he's not listening, he does not care. The bail hearing had to be extended by an apology of the justice because the defense lawyer, for 40 minutes, I'm not sure if he took 3 breaths, would not stop talking. As a result, we had to go back 3 days later, and then he was provided bail. Again, there's no motion, there's nothing. there's no feeling, and it's a slap in the face to the government that passed these features that we're living with today. It's a slap in the face to the police force that have to deal with these people.
He showed no emotion.
None.
He showed no care because he knew he was getting out. That's what this Liberal government's failed justice policies for the last 10 years have instilled within the criminal element in this country. It has emboldened criminals to do exactly what they are doing and terrorizing communities. Thank you for that. To the officers, both of you spoke about first steps. This was a good first step in the government introducing Bill C-14, but you would both acknowledge that while it talks about making it tougher for individuals to obtain bail, the same language that they used with the disastrous rollout of Bill C-48 by expanding the list of reverse onus charges, when you had members of the government, including the Prime Minister of the day and the former Justice Minister, proudly stating, "We delivered bail reform. These repeat violent criminals are going to be detained." We know that was a false promise, a false declaration, because we found ourselves right where we are right now with catch and release. Will you both agree with me that there is not a pathway in Bill C-14 for automatic detention? Yes or no?
I would agree with you, yes.
Right. It still vests discretion for judges in bail matters, particularly when you're dealing with violent repeat offenders, to still be granted bail. And the bill clearly states that when a justice makes a decision to release, it has to be on the least onerous conditions. I want to talk about that because that's one thing that we're not talking about in this committee, which is the sufficiency and the degree by which conditions need to be established. I have heard horror stories across this country of judges refusing to list conditions because it's an invitation to breach, or they're not addressing conditions reflective of the crime and the impact to the community or the victims, or they're making a joke of the promise to pay by requiring offenders to pay 5 cents. This is what's happening in downtown Toronto as we speak. Do you think that type of activism by our judges is appropriate to deal with community and victim safety?
Yeah, I think there's lots of work that we can still do around sureties. I think, in the Antic decision, it said that a pledge for a deposit performs the same function as actually giving a deposit. Quite frankly, that's nonsense.
Do you agree with that?
No, it's nonsense. And so, we need to do more work around sureties. We need to ensure that some sort of deposit is received by the court. We need to ensure that we're doing proper checks on sureties, that we don't have these sort of career sureties showing up repeat time and time again, vouching for someone who's been accused of an offense, that they're going to ensure that they abide by their conditions, knowing that they've put a pledge for a deposit, knowing that they're never going to have to pay that. It's never going to be collected.
Thank you, Mr. Baxter. Ms. Latanzia, 6 minutes.
Thank you, Mr. Chair. My first comments are for Mr. and Mrs. Beth. So just let me start by saying how deeply sorry I am for your loss. And your family story is quite devastating, to say the least, and it shows how devastating it could be when someone who's got a long record of breaking bail is released. So you've heard about us speak about Bill C-14, which was introduced last week by the Minister of Justice, which strengthens and makes a bail and sentencing tougher. So it was also made with the scope of also preventing the incidents that happened in your family by happening again. So, it would require the courts to consider the offender's history, past breaches, violence before granting release. So from your perspective, how critical is it that the change to ensure that no other family go through what you've gone through?
It's an important step that this is a beginning to establish a framework that once it's passed, then that framework, as we carry forward, any deficiencies as a result of the experiences can be tailored to protect society.
Would you like to? Yeah.
Yeah, I think the other thing is that it's still giving the judge the opportunity to make a decision. And I think that our judges need stricter criteria when they're making those decisions. For example, you know, she could still have let Mr. Hilt know, you know, still the 3 times or whatever. But what we saw from those 3 times, that there was actual escalation in the charges from the first one to the third one. But she's still, like, it was still okay for that judge to make that decision. If there were some clearer guidelines put in place each time, you know, if there's an escalation, if there's drugs, if there, you know, whatever, our judges need more support in, besides just at their discretion. That's not good enough.
My next question is to you, Mr. Baxter. Sorry, Mr. Morton. Sorry about that. From your frontline experience, how would Bill C-14's bail reforms change what officers face from day to day in keeping communities safe?
In Brantford, as I had stated in my opening comments, we are often arresting the same individuals repeatedly that have an outsized impact on both the police service and the criminal justice system. If you look at our crime severity index that was posted for 2024, and the comments made by our chief, Chief Saunders, a decrease in the crime severity index can often be caused by 1 or 2 individuals that are being detained in custody to cause those charges or offenses to stop happening while those individuals are in custody. And by keeping those repeat violent offenders in custody, it helps protect the rights of the victims and the community.
And how would you say that Bill C-14 delivers on the concerns raised by police officers?
I would say that Bill C-14 addresses quite a few concerns that the Police Association of Ontario has been advocating for over the last several years in regards to expanding reverse onus bail hearings, along with the fact that it's making more stringent conditions for judges or justices of the peace to retain individuals in custody.
Would you say, in your opinion, that consecutive sentencing would also help?
I would say that consecutive sentencing, if it was used appropriately, would help indeed.
Okay. And we've heard time and time again that there's a coordination between provinces and the federal government. So in your opinion, that coordination would mean what? Do you believe it is needed to ensure that these reforms would work on the ground?
I believe that a standardized training program, I was shocked to learn that justices of the peace don't have standardized training across Canada. I believe that that would be instrumental in making sure that the criminal code along with the charter is properly applied when dealing with repeat violent offenders.
Can you give us a little bit more details in terms of what would the training entail? What would you want to see in terms of the training specifically?
Currently, right now, as I had stated, I don't believe that there's any standardized training for justices of the peace across Canada. It would be nice to see that training specifically around maybe the latter principle, along with the opportunity to make sure that sureties are staying in compliance with addressing the concerns of not having the individuals just out, like President Baxter had said, about the professional sureties that just come in. They may not have had any interaction with these individuals for quite some time, and then they're vouching to say that they're going to keep an eye on them with no real consequences if those individuals end up breaching those conditions.
Thank you. Merci. À vous, Monsieur Fortin, pour 6 minutes.
Thank you, Chair. Thank you, all witnesses, for being here with us today. I would also like to extend my sincere condolences to Mr. and Mrs. Best for the death of your daughter. Right now, to place an accused on bail, there are three criteria to be assessed by the court. First of all, do we believe that there's any danger that the person may not appear in court when required? Secondly, is the person a threat to public safety? If the person is released, he may place people in danger. And the third criteria, will public confidence be undermined if that individual is placed on bail? The three criteria are in force right now. And what we are talking about is to reverse the burden of proof. So the accused has to prove that he meets the three criteria, and that onus is being reversed. Rather, it's the opposite. The Crown has to prove that the person may not appear in court, is a public danger, or doesn't respect the administration of justice. So the accused is being asked that they are not posing any danger and they will attend court for their trial. So in your opinion, this reverse onus, will this change anything? And if so, I would like you to tell us. Maybe Mr. Baxter first.
Sure, thank you. Yeah, so for the on a reverse onus offenses, first of all, what we're talking about here is limited scenarios where the starting point for violent repeat offenders is detention, and then the onus is on them to show why they should be released from custody. These changes, to me, along with clarification of how justices should be applying the latter principle, the principle of least restraint, seems to me that once this bill becomes law, it's going to have a real impact on this group of people that we're talking about that are continuing to victimize our communities.
Donc, si je comprends bien.
So, in your opinion, we could detain people before their trial if we were to apply that. Is that what you're saying? They could be detained while waiting for their trial?
Yes, we would. That is the intent. We would detain people who have met the criteria, who are dangerous, who are violent, who are repeat offenders. We would hold them in custody ahead of their trial, so they can't be out re-victimizing communities.
L'Association du barreau canadien.
The Canadian Bar Association claims that this reverse onus principle is useless. Have you talked with representatives of the Canadian Bar Association?
I've not spoken with anyone from the Canadian Bar Association about this.
Okay. Présentement, les
Right now, statistics tell us that in our prisons, 72% of people detained are there not because they were convicted of a crime, but because they are awaiting trial. Don't you think that those statistics are disturbing to believe that our prisons are simply keeping people who have not been convicted? Only 28% of those in prison will be convicted felons. Is this not disturbing?
We have to ensure that we have safe communities, and the way that we have safe communities when in the face of repeat and violent offenders, those accused of the most serious offenses and violence crimes, that they remain in custody until their trial. That is how we can keep our communities safe, and we see it far too often where people who are accused of very serious violent offenses, terrorizing, victimizing communities, they're released, and they continue to commit these same or similar violent offenses.
Je comprends.
I understand. Mr. Baxter, what we're talking about is the seriousness of the charges. So the Crown prosecutor decides to accuse someone of murder or homicide or any other crime. It does not necessarily mean that the person is guilty. Don't you think it's better to maybe look into repeat offenders instead of saying somebody has a blank criminal record but accused of a serious crime, wrongfully or rightfully, and meets the criteria for release, shouldn't you focus on repeat offenders, those who have already been convicted for similar crimes? Is it not better to have this balance in the justice system?
I think, first of all, the Crown's not deciding who they want to charge or who they want to accuse. The police have gathered evidence. They've conducted a criminal investigation, and through that investigation, they've determined that someone, they have reasonable probable grounds to believe that someone has committed an offense.
Mais
And
je
if
suis
it
d'accord
reaches,
avec vous. Je m'excuse, je ne veux pas être impoli, mais
I'm sorry, I don't want to be impolite. Time is running by. I think I have just a few minutes left. I understand. I have no doubt that the police officers are doing a good job, because we're trying to find the right balance between public safety and respecting the freedoms of everyone. Shouldn't we use repeat offense as the criteria for reverse onus instead of the seriousness of the crime?
sorry, did you say I can answer? Yeah, I think we can use both. I think we should be looking at the seriousness as well as the repeat offenders.
Merci. La deuxième ronde.
The second round is starting. I'll start with Mr. Latton, Mr. Chang, followed by Fortin, Mr. Leslie, and we'll end with Mr. Chang once again. Andrew.
Thank you to all the witnesses for being here, and to the best, I cannot convey enough how deeply sorry I am for your loss and that the system failed your family and your daughter so much. Ms. Dunn, I'd like to start with you, and just by way of disclosure, my wife does sit on the board of your organization, so I'm very familiar with the work, and we've been supporters since long before then, so thank you for your advocacy on this. We heard Mark Roskamp, the St. Thomas Police Chief, before this committee, and he had said in another session that 58% of those charged in St. Thomas with offences related to intimate partner violence are repeat offenders, and many of those are on bail. You deal with the victims of this. Does a stat like that surprise you, or does that conform with what you understand about the perpetrators of intimate partner violence?
Thank you so much for the question, MP Lawton. I think, that goes right in line with what we see here on the ground. And what is even more important maybe to mention is, that doesn't necessarily include all of the women who choose not to report to police, right? And so I think the numbers are not shocking, and Stats Can put out a report just came out today and it showed that between 2018 to 2024, IPV charges were up by 17%. And that statistic is not shocking either, because we are busier than ever. In the past year, we've had over 10,000 service interactions at our tiny little organization here in London, Ontario. So
there is a bill before this House of Commons, a Conservative bill that would treat the murder of a current or former intimate partner as first-degree murder, regardless of whether it was planned or deliberate. It would also create a new specific criminal code offenses for assault of an intimate partner and criminal harassment of an intimate partner. Would these measures be ones that you would encourage the House to pass?
absolutely, I would. I think that we need to look at those types of crimes individually. I think that when we're looking at intimate partner violence, it is very much a gendered issue, and violence against women is not on a decline. And I think it's very important to look at any type of law or legislation that can support ending violence against women.
In your initial testimony, Ms. Dunn, the trauma and pain that offenders being released on bail causes to women, to victims, you mentioned that they have to move oftentimes. What is the process itself like of these bail hearings? Does it respect the women who are dealing with trauma and dealing with these offenses in your experience?
Absolutely not. We have had women who refuse to call the justice system anymore. They call it the legal system because they feel as if they are not seeing enough justice done. It is very, very much a problem with, bail happening and women not being informed, or it being difficult for them to find out what's happening next. And that's an ongoing issue. And it's organizations like ours, and we're so thankful to have such amazing community partners here in London, Ontario. And we can work together to support women who are being or who have been subjected to this type of violence and who are involved in the criminal justice system at no fault of their own. Navigate through that and figure out what is happening next, because sometimes it's like I said, very difficult to get information.
Thank you. Moving to you, Mr. Morton, we have heard from this testimony before a concern that there is this wide gap between legal theory and experiences on the ground, the realities that your members and your colleagues have to contend with. And I note some of the Liberal witnesses have come from academic backgrounds where they have never even spoken to, as part of their research, victims. They are solely focused on the rights of the accused. What is the danger of that way of approaching criminal law?
The danger in regards to that is we are putting the offender's rights above families and victims of these serious and violent crimes that are happening, and it's not taking a fulsome approach in regards to reviewing what needs to be changed or what should be considered to be changed moving forward.
Thank you. Thank you. Wade, 5 minutes.
Yeah. Thank you, Chair. To Mr. and Mrs. Best, we are very sorry for your loss, and my sincere condolences to you and your families. So my very first question goes to Ms. Dawn. In your work with survivors, how often do you see cases where violent partners end up reoffending while on bail?
We see it all of the time. The one example that I gave, where we were working with a woman whose mother was the surety for the perpetrator, that that was not a good situation here for the woman that was accessing service. I think, like I said in my speaking notes, the woman could not even access our service without a safety plan. It was difficult for her to come to a service like our organization would provide. And so we see this time and time again. For example, when I told the staff here that I was going to be appearing before all of you, I had numerous staff members want to share stories with me to bring forward. So this is not an unusual circumstance for us here.
Thank you. And in your experience, what is the best way for the justice system to protect victims while still being fair to the accused?
We think it's very important for the system to work as much as they can right now, the way the system is structured, with a trauma and violence informed lens and trauma and violence informed approach. I think it's really important, to look at what maybe targeted accountability could look like. You all have a very big job to do, and we need to see high-risk repeat violent offenders to face detention. But we have to remember that this is not one size fits all, right? And we really have to recognize that, without the proper implementation in place, it's just simply not going to work. So everybody has to work together in order for it to work properly. And what I mean by that is that, if there's a woman on the other side of what an accused is going through with the criminal justice system, she needs to be informed every single step of the way. There needs to be accountability from the criminal justice system in that regard as well, not just for the accused. Victims do have rights as well, and it's really important for those to be considered every step of the way.
Thank you. And from your perspective, how would making it harder to get bail help keep women and families safe?
When a violent offender has been released on bail, women are constantly fearing for whether it's their lives or their safety. They cannot leave their homes without fear. They are constantly looking over their shoulders to see, what's going to happen next. And it's very difficult to live like that. And nobody should have to live like that. And just to be clear, it's very important that those types of experiences are considered when looking at changing any legislation or law. But the reality is, organizations like ours, we are working every single day to work ourselves out of a job. We don't want to be in 2025 having to provide service over 10,000 times in a year. And we really need to make sure that every single system is working together to provide every opportunity for real justice.
Thank you. And my last question to you is that beyond changing the law, what kind of support do we need to make sure that reforms actually keep women and families safe?
You have time for a brief answer, Ms. Dunn.
Sure. Quickly, I think it's very important for all of the systems to work together. So I think this is an opportunity to, I think, like I said in my speaking notes from, I have it open right here, the courtroom to the counseling office. Like, we all share the responsibility to support both survivors and victims and families, and also the perpetrators of the violence. And that comes with education and prevention and proper funding all across the board.
Thank you.
2 minutes et demi. Oui.
Merci, Monsieur le Président.
Thank you, Chair. Let me come back to Mr. Baxter. It's not that the other witnesses are not interesting, rather. Mr. Baxter, Madam Best told us something that we may add a condition, maybe drug addiction. I don't remember the exact words she used, but she talked about considering drug addiction when considering releasing someone on bail. In your opinion, is that a criterion that should be added? And in any case, I would like to know what you think about the criteria. Let me repeat them. Make sure that the person appear in court when required, the person does not pose a risk to public safety, their release does not undermine confidence in the administration of justice. So, Madam Best thought about adding a condition related to drug addiction. Mr. Baxter, what do you think about that? What additional criteria should be added?
I think that if we are continuing to talk about repeat and violent offenders and their drug addiction as part of that, then that becomes part of the conversation and part of the context that takes place at a hearing, at a bail hearing. I think we have to remember that the reforms that we're talking about here, we're not talking about everyday petty theft, right? We're talking about the worst types of repeat offenders who are defying rehabilitation, flagrantly running afoul of the law, and continue to victimize our communities. And that's who we're talking about. And if we're looking at reverse onus criteria as to whether or not they should be released within those 3 criteria that you have laid out, if they have alcohol or drug addiction issue, that's going to form part of the context that will take place in the bail hearing, part of the considering factors.
Le fait qu'il y ait ou pas récidive, que ce soit un crime violent.
Whether they are repeat offenders or not, it's not a violent crime. Drug addiction, drug or alcohol addiction, those are the conditions that should be added, if I understand you well.
Can you repeat?
Je disais le fait qu'il y ait un problème d'addiction, que ce soit une récidive.
The fact that there's addiction, repeat offense, violent crimes, those are the 3 criteria we should consider. Is that what you're saying?
In terms of the drug addiction and whether it's considered, that's always going to be considered by a justice during the bail hearing anyway. That context is there now for whether we're talking about a reverse onus offense or a not reverse onus offense. The person's alcohol or drug addiction or dependency is going to form part of the conversation, part of the discussion that will take place in bail. And we have seen times, mental health also plays into that. And we have seen times where folks are released and provided with opportunities to seek treatment and counseling.
Merci. Merci.
Thank you.
Brandon, 5 minutes.
Thank you, Mr. Chair, and thank you, Mr. and Mrs. Best, Michelle, Ron. I want to thank you for your courage in coming here today and sharing your story with such incredible composure, given the circumstances, and for your relentless advocacy and efforts to try to change Canada's bail system in the aftermath of the terrible tragedy that your family faced in honor of Kelly, but with a focus on ensuring that other families don't face the same devastation that yours had to. I know Kelly a little bit, and she's a wonderful human being with an incredibly bright future ahead of her, and she did not deserve to have her life taken by a man who should have been behind bars. I am so sorry for the loss that your entire family has faced, for the loss of Travis, her fiance, for all of those that knew and loved her, and frankly our entire community, my hometown of Portage, which was badly shaken when the news came out, which turned into pure disgust when the circumstances of how this tragedy came about. Kelly faced the consequences of political decisions that put the rights of criminals above the rights of everyone else. Her death should not have happened. Now, the individual who killed your daughter was given bail 3 times within 2 weeks prior to this tragedy. How does it make you feel to realize that the system as it currently is set up seems far more concerned with his rights than the safety of your daughters?
It's a feeling of like you just feel defeated because there's so many things that go through your head when you ask a question like that. Just the fact that there's just no, like they just simply don't, the suspect just simply doesn't care about society. He was released on his bail 9 months after spending time in prison. September 5th. September 6th, he absconded. September 7th, he posted on his social media, fresh out of P-W-E-Z-Y, no regard for the family, nothing. Monday, we discovered from Victim Services that he was released on Friday and left within 6 or 7 hours. So 4 days after we discovered that, Tuesday we were at a press conference, and at 3 o'clock that afternoon, 4 to 5 days after he was released and absconded, a warrant for his arrest was issued, and he was picked up, I think, within 20 minutes. So, whether or not that answers your questions, when those types of questions come up, those are the things. It just leaves you bewildered how it can happen.
It goes to show that our police are doing their level best, and thank you all for the work that they do. Now, you've lived through the worst imaginable outcome of a failed system. If you could speak directly to the lawmakers that have defended for years the status quo of this system, what would you say to them?
To speak to what you hear about rehabilitation, the importance of rehabilitation, and they need help, and it's in this case, and I think in most cases, if it's a justice or a judge that's giving this person bail, not only you're not doing the family any favors, but you're not doing the individuals any favors. They just can't, if you let that individual out, they just don't understand it, and they're going to go and do exactly what they were arrested for previously. And
I think my comment would be, we need change. We're continuing to do the same thing over and over again, expecting a different result from people who are not able to make different decisions. And by just releasing them back into our communities, we're giving them the go-ahead to continue their behavior. This is not something we talk about for initial offenses. This is repeat, and I think that that's a key word. And if I could speak directly to them, please make these changes.
Thank you. And just quickly, what message does it send to victims' families when someone who repeatedly breaches these conditions is yet given another chance by a judge?
It gives the message that
There's a button right in front of you, Michelle.
Okay.
Perfect. You'll see a red thing go on.
we want them. We felt at a loss. We felt discouraged. We felt that his immediate needs were being put over the situation that our family has been put in. She's a huge loss, not only to our community, as Brandon mentioned, but to our family. She was a pillar in our family, and it didn't matter. And no one asked us the question, and no one considered his previous behaviors either. When you talk about the fact that previous drug use should be mentioned in bail, there was no mention of his previous history. His defense lawyer made us think that he had previously been one of Sentis helpers. So it's important that the accused have a chance to speak and that the judge have a chance to make some better assumptions based on history.
Thank you. Thank you both. MP Chang for 5 minutes.
Yeah, so I got one more question for Ms. Dunn. You have mentioned the danger women face when violent partners are released after multiple breaches of no contact conditions. Bill C-14 now requires judges to consider that pattern of violence and expand reverse honest provisions for repeat offenders. From your perspective, how important are those changes to keeping survivors safe?
Thank you so much for the question. I think that those changes are very important. I think those changes should come with perhaps increased education and training for the judges making those decisions on the nuances of intimate partner violence and sexual assault and human trafficking and anything that falls under the spectrum of violence against women. It can't be assumed that all judges would have all of the information that they need to move forward with a decision, and so I think that would be really important. But those changes with this new bill in front of all of you, I think are a good step forward.
Thank you. And my last question is to Mr. Morton. Would you urge all parties to support Bill C-14, and why?
Yes, I would encourage all parties to support Bill C-14. As I'd stated earlier, the Police Association of Ontario has been advocating for lots of these changes over recent years with the full support of all associations across Ontario, at least. I can't speak nationally, but in Ontario, all police associations are in agreement that things need to change.
Thank you. I have no further questions, Chair.
Okay, thank you. And presuming to speak on behalf of the committee, but I do want to thank you again, Michelle and Ron, for your courage today in coming here. And this testimony has not fallen on deaf ears. It did, again, take great courage for you to come here. And on behalf of the committee, personally as well, I do want to extend my deepest condolences on the loss of Kelly and to all those that loved her and knew her. So thank you. And I'll leave, obviously, Mr. Best, I will leave you some words. We do have a couple minutes before we have to switch over, but I do want to just thank the rest of the witnesses as well for their important testimony.
Thanks, Mark. Just, it's important for everybody to imagine when you arrive at a crash scene and see the vehicle absolutely obliterated and say, boy, my girl was in there. And you're very, very thankful that members of law enforcement are on that scene, and they don't let uncles in, they don't let aunts in, they let in my wife and I and her fiance, and we have to be very, very thankful to have those law enforcement people present at those scenes, because they are absolutely terrifying, and that is one of the chain links, if you will, that's occurring as a result of this policy of just essentially these criminals are just waiting, looking at their watch if they have one on, and looking at their lawyer and saying, "Did I get out? Yes or no?" Because I got to get back to my cell. I mean, I just wanted to say that in closing, because it's really important to law enforcement. We're really helpful to Kelly's fiance, to my wife, and to myself. And you really appreciate it, because it's a very, very haunting thing to go into.
Thank you. Thank you. We will suspend for a few minutes to switch over to the next round, and we'll resume in about 5 minutes. Thank you. Bienvenue à cette, bon, j'aurais dit la deuxième heure, mais...
Welcome back to the second hour and a half, the second panel. I will not repeat instructions to the letter. I know many of you have been witnesses here before. I simply want to remind you that you should try to maintain a certain distance away from the microphone to protect the interpreters. You have some guidelines on the table before you. For those online, you are necessarily familiar with, you may be familiar with Zoom. Use the raise hand function. Witnesses will have 5 minutes per group. Mr. Jelina and Mr. Weld from the SPVM, you will have 5 minutes for you both. Then the BC Crown Counsel Association, 5 minutes. Canadian Association of Chiefs of Police, 5 minutes. Center for Trauma-Informed Practices, 5 minutes.
Through this, but we had a slight delay with voting. So we want to get going and have a good time for the members to pose appropriate questions. But we have appearing today, André Gélina, Sergeant Détective à la retraite.
Sergeant Detective retired, Mr. Wells, retired as well from the Montreal Police Service.
Association, Adam Dalrymple, who is online. L'Association canadienne des chefs de police, Thomas.
Canadian Association of Chiefs of Police, Thomas Carrick. Commissioner, Center for Trauma-Informed Practices, Patrick River, Director of Canadian Operations, appearing via video conference as well. We will proceed using the order of the introductions. Mr. Jelina, 5 minutes. Mr. Dalrymple, 5 minutes. Mr. Carrick, 5 minutes. And Mr. Patrick River, 5 minutes. My regards to member of the committee. I'm a retired detective sergeant specialized in intelligence and use of forces. We've been trying to educate the public since 2021 on the importance of looking into the situation of repeat violent offenders who have been very protected in Canada. We want Bill C-75 to be replaced or to be reviewed. Gabi Renaud from Saint-Jérôme. Does this name ring a bell? This is the 14th victim of domestic violence in Quebec in 2025. Let's not minimize those cases, as some previous witnesses did before you. Jonathan Blanchette had many charges for domestic violence crimes. Bail conditions were imposed on him 16 times. If this lady were your daughter or your sister, will you still trust elected officials or the justice system that gives a lot of chances to violent criminals to continue committing crimes? We are all for rehabilitation. What we are asking is a balance between rehabilitation and the protection of the public. Many women are victims. Lawmakers have to understand that crimes against property and crimes against individuals should not be treated the same way. There should be a clear escalation of charges to end the judicial laxism and make sure that public confidence returns. When it comes to home invasions, there should be greater chances of rehabilitation than those given to violent criminals. If somebody commits violent crimes against women, be it proxenetism, harassment, and so on, such crimes should be dealt with severely, at least 2 years, the second one 5 years, and so on. The lawmakers should act seriously against repeat offenders who are underrepresented in some communities and were accused 4 times for crimes against individuals and did not take opportunities offered by the system to be rehabilitated. There are exceptions that are possible. People are released after a 4th charge, but with a label of controlled offender. And these people could also be imprisoned for a long time. Those who do not respect their bail conditions 3 times should be detained to make sure that the public is protected. The lawmaker should no longer simply manage risks on the back of the community and protect the rights of the accused. Thank you for listening to me. Mr. Chair, ladies and gentlemen, thank you for inviting me. Andre Jelina, Detective Sergeant, retired from I worked as a patroller, supervisor, investigator, intelligence agent, organized crimes, terrorism. I worked 4 years at the Correctional Services of Canada on working on bail, supervising criminals in the community. I also worked for 9 years in Afghanistan during the war. Over the 5 last years, I've been an analyst for various media houses. We should understand that the current system on paper gives us proper protection. However, it's based on the good will of criminals who commit to respect bail conditions while waiting for their trial. The current system is very naive. It takes it for granted that criminals will respect the various conditions of release. Unfortunately, we realize that many of them do not respect the conditions, and we only realize that when there's a tragedy that is committed, particularly during domestic violence. We must either increase the gravity or seriousness of the conditions of release or significantly increase surveillance and make sure that they respect the conditions imposed by the courts. There are many types of criminals where we have to intervene to protect the population and the victims. For example, organized crime, domestic violence, sexual violence, home invasions, illegal weapons trafficking, sale of drugs, fraud against seniors, and so on. All violence that is unprovoked should be dealt with severely because we cannot allow the public to be subject to such crimes. Those using weapons should also be dealt with more severely. I would also like to talk about individuals who are working for criminal organizations, taking advantage of minors and using them to commit terrible crimes. Thank you.
Mr. Dalrymple.
Yes, thank you. My name is Adam Dalrymple. I am the president of the British Columbia Crown Counsel Association and the vice president of the Canadian Association of Crown Counsel. And I'm employed as Crown Counsel here in Vancouver, British Columbia. And I've been on the front lines of this prosecution service for about 17 years, just over. I'm honored to be invited to this committee as a witness, and I hope that I'm helpful to the committee. However, I should preface my comments by saying that I'm not permitted to speak about specific cases and active prosecutions. I'm also not able to speak on behalf of the BC Prosecution Service or the government of British Columbia. As president of the BC Crown Counsel Association, I represent approximately 550 frontline criminal prosecutors who work in British Columbia criminal courts. We represent them in all aspects of their professional employment, and our association was established approximately 33 years ago. The law of bail and sentencing, particularly in respect to repeat prolific offenders, is at the forefront of Canadians' minds. I've traveled the province of British Columbia and listened to mayors, council members, business owners, and our frontline prosecutors. This outreach, coupled with my years of experience in the criminal courts, informs our views on this important topic. Our association would urge legislatures and policymakers to look at the issue of bail and sentencing in Canada from a holistic perspective. No one level of government in our Canadian system of government holds all the answers. Given the division of powers, as you know, the federal government is charged with deciding what is criminal in our justice system. The provinces are largely responsible for the administration of justice. This means that most of our criminal courts and prosecution services are funded and staffed by the provinces. Many of the social services that are provided by provincial and municipal governments. Passing tougher laws is not the only way to address offending in our communities. Laws must be supported with sufficient frontline resources and services to investigate and prosecute offenses. There must also be sufficient local services in place to support and monitor those who are on bail in our communities while they await their trials. The organizations I represent are calling for the hiring of more frontline, and when I say frontline, I mean courtroom prosecutors. While we appreciate that the hiring of most criminal prosecutors is within provincial domain, we stress the importance of a coordinated, multifaceted approach. By limiting the ratio of frontline Crown to accused, building a national bail information system that transcends provinces, and funding local police Crown projects and social services in communities, we believe that the federal government will have the desired impact on crime and repeat offenders in Canadian communities. The REVOI, which is an acronym for Repeat Violent Offender Intervention Initiative, developed by the government of British Columbia, is just one example of how a Crown program can reduce offending, uphold the rule of law, enhance public confidence in the justice system, and keep our community safe. Thank you.
Commissioner, over to you.
Good afternoon, and thank you, Honorary Chair. I really appreciate the opportunity to address the Committee on Justice and Human Rights. The Canadian Association of Chiefs of Police have continually advocated for legislative improvements to advance public safety. It is encouraging that the government is proposing amendments to the Criminal Code to create safer communities, enhance officer safety, and improve trust and confidence in the justice system. There have been many egregious examples of repeat and violent offenders out on bail who commit additional offences, including homicide, such as the December 2022 murder of Ontario Provincial Police Constable Greg Piershala. I addressed this committee just 2 years ago on the issue of bail reform, and while there were some amendments brought about by the introduction of Bill C-48, it's evident that our work to ensure the safety and security of our communities is not done. The recent legislative proposals regarding bail and sentencing are welcomed by the CACP, who have repeatedly advocated for specific changes. In particular, we called for the broadening of reverse onus provisions for bail-related offenses that are violent or serious in nature. It's encouraging that the proposed legislation before the House recognizes the importance of this amendment, particularly with respect to offenders who commit violent offenses, weapon offenses, or those connected to organized crime. Direction regarding the principle of restraint and clarity that the latter principle does not apply to reverse onus are necessary protections to address public safety. Jurists must be given direction on how to properly apply the reverse onus provisions, and the strength of evidence an accused must present to meet it. It is the CACP's position that the burden of proof in certain reverse onus bail hearings should require clear and convincing evidence before the accused person may be released. The standard falls between a balance of probabilities and proof beyond a reasonable doubt. The CACP also advocates for new tertiary ground considerations when an accused faces multiple charges for failing to comply with release conditions. Bill C-14 will require the courts to consider the number or seriousness of any outstanding charges when determining whether to release an offender. This consideration, while recognizing that accused persons have a presumption of innocence, sensibly addresses the need to weigh the rights of the accused against the protection of society and the safety of Canadians. Additionally, CACP recommends including strengthening the instrument process to require specific information from a proposed surety and a limiting of judicial discretion to the forfeiture of the entire amount pledged. A more rigid forfeiture process compels accused persons to comply with their conditions and spares their sureties financial hardship. A surety is only as effective if the consequences of a breach are meaningful. The CACP has further recommended an appeal mechanism by the Court of Appeal for 525 detention reviews, since there is currently no ability for the Crown to seek a review of that decision apart from appealing directly to the Supreme Court. We are pleased with the intentions to address sentencing in Bill C-14, in particular sentences associated to serious sexual offenses. The consecutive sentencing provisions are a positive step towards addressing repeat and violent offenders in our judicial system. Also important is the primary sentencing objective of denunciation and deterrence for second and subsequent convictions relating to organized crime, auto theft, or break-and-enter offenses. The CACP continues to call for tougher penalties for intimate partner violence, along with firearm offenses, including the smuggling and trafficking of firearms. And while the Supreme Court has previously ruled on the constitutional periods for parole ineligibility, the courts could be provided with direction to lengthen parole ineligibility periods or assign dangerous offender designations for multiple murder convictions. We believe that still more can be done to address the issue of repeat and violent offenders and to combat organized crime. The CACP strongly supports the intention of the proposed legislative reform to ensure bail and sentencing deters crime, protects law-abiding Canadians, and strengthens victims' rights. In the interest of public safety, I urge the members of this committee and all members of Parliament to work together without delay to enact the meaningful legislative change regarding bail and sentencing found in C-14. The CACP is calling on Parliament to come together and collectively prioritize public safety in consultation with those who understand it through lived experience and operational expertise. Thank you. Merci. Make wedge. I look forward to any questions you may have of me, Honorary Chair.
Thank you, Commissioner. Monsieur Rivard, la parole est à vous pour 5 minutes.
Thank you, Honorary Chair, and merci à tous pour votre travail qui est vraiment important. Je vais parler en anglais.
Thank you very much for your work. I will speak in English. I just wanted to greet you first and thank you for your work.
So I really come to you not only as an expert in threat assessment and trauma response, but I've come to you as also a citizen and a community member in Canada. So I really thank you for your work in this important conversation. And so the Centre for Trauma-Informed Practice is a Canadian organization that works with multidisciplinary professionals, starting with our police officers, our probation officers, a lot of mental health workers, and we train many folks across Canada, 70,000 to be an estimate right about now, in really understanding the importance of having a collaborative approach to determining the issue of risk and risk assessment. And so the word risk assessment comes with really a lot of interpretation. And what we're asking the committee to consider is to have a little more of a collaborative approach around what is our definition of risk assessment and what data are the courts using to actually make informed decisions around repeat offenders, et cetera, et cetera. So our models are very much situated to fit into this conversation, to provide professionals with data-based decision-making, and to use multi-sectoral data assessments to make decisions around what we would refer to as the IOC, so the individual of concern. And so inside this conversation, what I would also just observe in our work, and our work is based, our research is based on about 45,000 cases of what we would determine moderate to high risk cases where there's a risk to violence, a risk to public safety, spanning from youth, school-age children, to adults in some communities as well. And one of the limitations in the work and doing collaborative work and really determining risk is the ability for professionals to actually share information amongst themselves. And so, again, it's an invitation to look at some of our legislations around what can we say amongst professionals to determine risk. And so there are some challenges inside of that. And I want to be clear when I present that I'm talking about when there is clear, direct, plausible threat in public safety. And the legislation does allow people to actually share information, but too often it doesn't occur. The other limitation I hear in practice from my colleagues is the ability, and I'm speaking to my police colleagues a lot of times, and I'm in Toronto right now doing some work with them, where searchability becomes an issue. So we may have a lot of idea around risk and dangerousness, where a weapon might be held in a room, a weapon might be held somewhere, and our police are struggling in being able to even execute exigent circumstances in the criminal code. And so I'm asking on their behalf in a lot of ways, and based on 45,000 cases, to maybe have a look at those kinds of restrictions that are placed around determining risk and dangerousness. So inside of the work we do differentiate between risk assessment and determining if someone is dangerous. And what often happens, and what we've been observing, is that sometimes the decisions made around bail are based on criminal history and not history of violence. And so somebody can have a history of criminalization and be actually at moderate risk in terms of being dangerous. However, there could be sometimes in situations where somebody has basically never had a history of criminality and be extremely dangerous. And the litmus paper test for maybe a bail restraint or a condition around bail is generally focused on a history of criminality. And so the information we would provide the courts goes beyond history of criminality. And we looked at a concept, and I don't have time to train everyone, of course. I have 5 minutes, but the concept of baseline. And so the concept of somebody's baseline who's engaging in pathways to violence is their typical pathway to violence. And the rule in our work is if they've shifted in their pathway, switched their target selection, then there's a higher level of dangerousness and risk based on what they're doing. So I know I'm running out of time, but I do want to share with you, I heard it before from some of my colleagues, the need for collaborative work in communities is something we see that we do well at CTIP. We have over 500 protocols in this country where multidisciplinary professionals work
sorry,
together.
I have to cut you off. It's gone.
Yeah, I do.
It went way over, but perhaps a member can follow up on that and ask you questions.
Thank you.
Continue your thoughts. But thank you, and thank you indeed.
Thank you for your patience. Merci. Yeah.
Thank you indeed to all witnesses in this round. We'll start off the first round, 6 minutes each, starting with you, Roman, then Jamie for 6 minutes, and Ms. Rial, 6 minutes. Et ensuite, pour la...
For the second round, 5 minutes, Mr. Lato, Latanso, Fortin, Brock, Lachan. We may have a third round before 6:30 p.m. Mr. Barber, you have the floor.
Thank you. Commissioner Carrick, welcome. You are here leading a force of almost 6,000 uniformed officers. I thank you for your service, and I salute your work. You may know that I used to serve in Ontario's provincial legislature, and I followed the OPP very closely. It's important that your officers possess high morale on the job. Is it fair to say that Canada's bail and sentencing laws dampen the morale of your officers?
Yes, sir, that is very fair to say.
Tell us a little bit about that.
Well, you can imagine when officers are risking their personal safety day in, day out, they're risking the sanctity of their families, their psychological and emotional well-being when dealing with repeat and violent offenders. And when these perpetrators are brought before the courts, and when they are released, where the officers can clearly see an elevated risk, they're released into communities and they further victimize innocent law-abiding Canadians, including police officers, in the lawful execution of their duties. It is very demoralizing for our officers.
Too often, we hear of one of our OPP heroes choosing to take their own life. Can you please tell us why you think that is happening?
That is a very complex thing to try to even put into to context, and I don't know that it belongs before this discussion here this evening, sir.
Sir, can you please tell me what this committee can do? What can Parliament do to strengthen morale in the OPP?
Bring about these bail and sentencing changes as quickly as possible. We are so encouraged right now. We saw the Conservatives bring forward Bill C-242. We've seen the Liberals bring forward Bill C-14. There's a joint interest in improving public safety across party lines. That has motivated and inspired law enforcement professionals. And if we can actually get the job done and make the meaningful changes that are being highlighted and incorporating the suggestions that your law enforcement witnesses are bringing forward, you will make a dramatic improvement on police morale, and more importantly, you will improve public safety.
Commissioner, I gather you welcome the expansion of the list of the reverse onus offenses, but C-48 had already done that with respect to a number of offenses, and even with respect to those offenses, we've still witnessed catch and release policies. So what, if anything, gives you the confidence that the Bill 14 will not have the same results as Bill C-48?
Well, I am encouraged by the direction and clarity that appears to be present in Bill C-14, where it clearly gives direction around the parameters of reverse onus and highlights those things that need to be considered, like tertiary grounds. And I do believe that we're going to need to monitor it. I don't know how effectively as a society we have monitored the impacts of C-48 and have been committed to making quick changes as opposed to the 5-year commitment that's embedded in the legislation to review the effectiveness of it. This is public safety, and it can't wait 5 years. We need to constantly be monitoring how these implications are affecting Canadians and making the necessary changes.
Commissioner, the challenge I see with Bill C-14 is that it does not clarify the burden of proof in the reverse onus offenses, nor does it completely remove the latter principle, which requires judges to propose the least restrictive terms of release. What do you say to that?
Well, as I indicated in my opening statement, we do believe there is room to further clarify that burden of proof, to be clear and convincing evidence that an accused will not violate a bail plan. And we absolutely endorse further clarity around the latter principle and ensuring that it is not applied in reverse onus circumstances.
I know that in advance of this legislation, various police forces from across the country urged the Liberal government to modify the cash requirement for bails to ensure that bail is complied with or else real money is forfeited. Are you disappointed that Bill C-14 is silent on cash bail?
I was very optimistic that proposed legislation would include addressing the frailties in the surety process that does not appear to be contained in the 80-some-odd changes to the criminal code, and we would welcome further ongoing discussion as to how we could see those amendments implemented.
We had a defense lawyer at committee last week who was a professional who, as a citizen, was perplexed that violent offenders are able to be granted parole after serving a third of their sentence again and again. Regretfully, we don't see any action on parole from this Liberal government and Bill C-14. Would you urge the government to reconsider that? And what do you see as the challenge with parole, and how do you propose to address that?
You have time for a very brief answer, Commissioner.
Very briefly, I would encourage much further discussion on that, and we at the CACP would be happy to assist.
Thanks, Chair. Thank you to all the witnesses for coming today to talk about this issue that we all agree is very important. And Commissioner Carrick, I want to say thank you, first of all, for your enthusiastic support for Bill C-14. I want to talk to you about two things you mentioned right off the top. One of them is the principle of restraint, and one of them is the success of C-48 and the monitoring component. We had this witness that Mr. Bobber just referred to last week was a criminal lawyer from Ontario, and his evidence was that the principle of restraint is not anything new. The codification was simply a reflection of the Supreme Court of Canada's ruling, and it's been around for generations. Was his evidence, and he said that it hasn't affected his practice one iota. He approaches it the same way now as he always has. Officer Wall, you referred to repealing C-75. I assume you were referring to the principle of restraint. You weren't referring to the provisions dealing with gender-based violence. First of all, Commissioner, I want to ask you, do you agree with that lawyer's assessment of the principle of restraint?
Not hearing the lawyer's testimony, what I will say is I feel that the principle of restraint needs to be clarified, and there needs to be direction to police and the judiciary that it does not mean mandatory release.
I'm glad you went there, because I've had many discussions with frontline officers in Toronto about C-75 and trying to understand what it is that they have trouble with. And the trouble they repeatedly tell me time and time again is that they were not trained or given any education on what it actually meant. And as a result, they've interpreted it somehow as meaning people should just get out easily. That's not what the bill says. It's not what the legislation says. In fact, quite the opposite. But having said that, you've reviewed C-14. C-14 addresses some of that component of the principle of restraint and giving frontline officers and people involved in the criminal justice system that type of information and that type of education, which will prevent that type of approach that you're concerned about. Would you agree with that?
In the time that I've had to review it, I agree that it does attempt to address the issue of principle restraint.
Okay. All right. Thank you. Now I want to talk about sort of the laws versus the enforcement, and I want to talk to Mr. Dalrymple. Sir, you talked about, it's not one level of government that bears all the responsibility, and we've heard this time and time again. If it's the laws versus enforcement. The laws can be there, but if you don't have the resources available with crowns and prisons and courtrooms, the laws are still going to face challenges when it comes to enforcement. Would you agree with that?
Yes, Mr. Maloney.
Thank you. So, again, I'll use my own example. In the province of Ontario, I have yet to meet a Crown attorney who tells me he's suffering from an excess of resources. I assume the same is the case in British Columbia?
Yes, that's correct.
And so we've heard evidence earlier in this study about bail hearings, and you'll have, in some cases, you'll come to court and there'll be a Crown attorney will have 25 bail applications, only has time to get through about 10. That means the other 15 either get disposed of by way of agreement or they get postponed. Is that a common occurrence in British Columbia as well?
In my experience in traveling the province, yes, there is what we believe to be triage taking place, where prosecutors are trying to get through court lists focusing on the more serious matters, and then some of the less serious matters are not given the attention in detail that are required.
Right. Or in some cases that results in people being released on agreement without actually going through the hearing process to try to triage the cases that they have on their docket. Is that right?
We would, in my experience, we still do a hearing before a justice, but it might be by consent. The Crown will agree to someone's release on, limited conditions, obviously in compliance with the law. But there may not have been an opportunity to sort of vet what the defense lawyer has said the accused circumstances are, or, for example, if there's a release plan, that release plan may not have been vetted by the prosecutor. They may not have had the time or resources to reach out to see if they're going into a recovery house, what's the reputation of that recovery house, and those sorts of things. So depending on the day and how busy it is, they may not have those opportunities to actually dig in deep on these files.
Right. So in your experience, the Crown attorneys are at a bit of a disadvantage because they don't have the time, the luxury of time, to do their preparation before these bail hearings, to have the necessary background information when they enter into these agreements. Is that fair?
In most cases, that's our belief. I was just at our Canadian International meeting in Halifax last week, and I understand that this is across the country, in particular large centers like Toronto and Vancouver and other places like that.
Okay. Do you have any concern that in the absence of the provinces increasing their capacity when it comes to crowns and courtrooms and detention centers, that these new set of laws will only create a greater burden on the system? The system might actually suffer worse than it does now?
Yes, so that is our concern. Unless you have a commensurate increase in the number of resources to deal with these matters on the front lines in the courtrooms of this country, we will not be able to handle.
Thank you. One last very quick point, and this is something Commissioner Carrick said. There's been no monitoring of the effectiveness of C-48 because that is exclusively in the control of the provinces. They have that data. They control the system. They're the ones in the position to actually make that assessment. So how do you think the federal government can encourage the provinces to actually do that?
We'll be able to follow up with that, Commissioner. Perhaps with another round, either with Liberals or others. Monsieur Fortin, 6 minutes.
Merci, Monsieur le Président. Merci.
Thank you, Chair. Thank you all witnesses for being here today. My question goes to Mr. Jerinas and Mr. Wall. One of you may answer. Right now, you know the conditions for bail. The Crown Prosecutor must show that there's a danger for the person not appearing. There must be proof that it doesn't undermine public safety or undermine the public's confidence in the justice system. Here, reverse onus is being proposed under certain circumstances. Does this seem to be inappropriate, or do you think there are other conditions that should be added to the 3 current conditions of release? Certainly, yes. That's a step in the right direction. Reverse onus is useful, but at the same time, we need to check because the commitments remain. Even though the individual makes a commitment, there are many other issues. It doesn't mean that those conditions will be respected. As I said during my remarks, unfortunately, we realize very often that those conditions are not respected only when a tragedy has occurred. We should be able to verify and make sure that the system will be respected effectively. Now, you're talking about conditions of release that should be better verified. My question has to do with the conditions under which a judge may decide to release someone. Let me continue in the vein of your answer. Conditions exist already. Courts impose conditions when someone is released on bail. Are those conditions severe enough or not severe enough? Doesn't the problem arise from the fact that there's no adequate surveillance or monitoring of the people released on bail? Is that not where the problem lies? I think that you've touched on the real problem. On paper, when an individual commits to respect the perimeter, to ensure peace and respect the law, theoretically, we are protected. But in practice, after a risk assessment, because of course all offenders do not pose the same danger or risk, at some point someone wakes up in the morning, there's no unit in Quebec, for example, picking up a file to make sure that Mr. X or Madam X respects the conditions. And this undermines credibility because other offenders would simply know that this is not truly being verified. This morning, not this morning, there's something I read this morning. People who had violated their bail conditions 93 times in 66 days. And this person was doing that to harass the victim, the former spouse. So what do you think about that in 20 seconds? It's simply lack of credibility on the part of the system, because once again, we realize that this individual is violating their conditions. Put yourselves in the place of the population and the victim and even the police officers. The commissioner talked about it a while ago. It's discouraging for everyone. Some witnesses came and told us that right now, prisons are filled by 72% of people who are in pretrial detention, compared to only 28% who are serving their sentences. When I learned about that, I was surprised. What do you think about that? Is it normal, or is there no problem of administration of justice? Because I find this horrible. But in your experience as a police officer, is it normal that 72% of detainees in our prisons are in pretrial detention? So we're building prisons for preventive detention. Well, it's good to break down the 72%. Most of them crimes, serious crimes against individuals or crimes against property. Are they repeat offenders? Well, you're right, but my question is looking into the justice system. Do we believe that we have a system that works when we are obliged to detain so many people before their trials? Is this normal? Maybe there are things I don't understand. This system can never prevent all repeat offenses 100%, and to make sure that people released on bail do not repeat their offenses. But if those people are detained at a high level, it's because those people committed acts that require that they be detained before their trials. Well, they are charged, so they represent a risk for society, and that a decision was made to detain them while awaiting trial. I'm sorry I have to interrupt you. Let me move on to something else. We were told that suspended sentences, for example, people serving sentences at home, are more difficult sentences to bear for a person convicted compared to a prison sentence. What do you think about that? Very quickly. When you can take advantage of the comfort of your home and you do not necessarily have a rehabilitation program to follow from the comfort of your home, you can watch all the shows you want on TV. That cannot be compared to a sentence being served in a prison where you are not deprived of your freedom. I think it's a deterrent for a criminal. Yesterday, a lady was accused of sexual assault against another lady and got a fixed term. We also have very laxist sentences, even for such crimes. Thank you.
For 5 minutes.
Thank you, and to all of the witnesses, thank you very much for your service. Law enforcement is very near and dear to my heart. I have a family member who actively is in the Ontario Provincial Police right now, Commissioner, so thank you for your time here as well. Just by way of pointing out the cruel irony of our work on this committee, 1 week ago, we actually had this meeting interrupted by an Amber Alert for a horrific situation in Brampton in which a young girl had been abducted, and we learned after that the abductor, the father, had killed the girl's mother, and sadly, unsurprisingly, was out on bail at the time. And you mentioned, Commissioner, in your testimony, the murder of Greg Priscilla, an OPP officer that I know sent a chill throughout policing across Ontario and the country. And again, the perpetrators, repeat offenders, out on bail. So we have these situations, and I heard from a lot of police officers the sense that when the killing of Constable Priscilla did not trigger immediate bail reform, nothing would. That was the fear that I heard from a lot of officers, where they, to Mr. Baber's questions earlier, had really just allowed the morale to take a huge hit. And you did testify to that earlier, but what is your sense and what is your feeling that it has taken so long to have a piece of legislation that purports to address these concerns that you and your colleagues have been raising?
Well, as earlier stated, I do believe that the time is now to make additional changes. I do appreciate the attempts that were made in C-48. We do know that the data does show that there are more people out on bail today in many jurisdictions than there were pre-C-48. We also need to get to the qualitative pieces of it, just not the quantitative, to determine, are we making the right decisions around bail? Are we truly protecting Canadians? The time to act is now, and I think we've never been in a better position to achieve real results that prioritize public safety.
When you mention the high number of people out on bail and the issues that we've been seeing perennially, not just on this committee's work, but in the news for many years of revolving door bail, what is the effect this has on the resourcing of police departments?
Well, it has a dramatic effect on the resourcing of police departments. You know, we have in the province of Ontario what we call a bail compliance dashboard, which are offenders that are repeat violent offenders out on firearm-related offenses. We have over 2,000 offenders registered on that database, for which we have checked more than 14,000 times. So it is very resource intensive, but there's not a lot more important than ensuring repeat violent offenders are abiding by their conditions.
And is it a better use of police resources to monitor those conditions, to monitor people who are illegally using firearms? Is it a better use of resources to do that than to be involved in collecting firearms from licensed, law-abiding firearms owners?
We would absolutely prioritize the enforcement of repeat violent offenders.
In your capacity as with the Canadian Association of Chiefs of Police, but you're also the Commissioner of the Ontario Provincial Police, which has declined to participate in the Liberal government's firearms confiscation scheme. There are a number of police chiefs of Ontario municipal forces that have also spoken up and said they do not believe this is a legitimate use of their resources, given these issues with bail that are taxing and stretching them. How pervasive is that sense within the police chiefs that you represent?
Many police services, almost every police service across this country, is tasked with the demands that are put before them. Unprecedented amounts of civil unrest in our major urban centers, increasing crime in rural areas, repeat violent offenders that need to be monitored, crime guns that are coming in from the U.S. in unprecedented amounts. We will exceed over 2,000 crime guns this year again. 91% of them are coming in from the U.S. These are the dangers. These are the strains and drains on our resources, and this is where we need to be spending our time and our attention.
And just to confirm, you're saying that these are not guns that are lawfully owned and purchased through the legal means in Canada that are causing the gun crime problems that you're forced and your officers are forced to deal with?
It is very rare that a lawfully possessed firearm in our country gets categorized as a crime gun and is used in a violent act. our issue, our concern as Canadians should be on those crime guns that are primarily coming from the U.S. They are illegal from the day they arrive, and we need to focus our attentions on the border to lock that down.
Thank you. Ms. Latanzio.
Thank you, Mr. Chair. Thank you for all the witnesses for being here present today. So before I start my question, I'm going to turn it over to you, Commissioner Carrick, and give you the opportunity to respond to my colleagues James Maloney's questions in terms of the province's responsibility of sharing data in terms of evaluating or measuring the effectiveness of our laws, such as the C-48. So we'd like to hear you on that.
Thank you very much for the opportunity to respond. And as has already been articulated, it's the federal government's responsibility to establish criminal code legislation. It is the province's responsibility to administer justice in the province. There is a shared responsibility across this country to ensure that data related to bail is going into one central repository. So, one, we can evaluate the effectiveness of the legislation. Two, we can evaluate the performance of the administration of justice. And three, we can incorporate lessons learned to make the necessary changes as we move forward. I can tell you from the province of Ontario perspective, we have more people out on bail today than we did pre-C-48. That is an indication that we need to pay close attention, but we also need to drill down to the qualitative pieces of those to determine what did not work in the bail process that resulted on those offenders being out on bail and then recommitting other serious and violent offenses.
And so how do we institute procedures or ensure that we get the qualitative evidence and the qualitative data sharing?
To me, it doesn't seem like an overly complex problem. This is an opportunity for all levels of government to work together, to make it a priority, to focus on a centralized records management system for policing right across this country, to implement key performance indicators for the judicial system, and that data gets shared and evidence-based decisions are made moving forward.
Okay. Merci d'être des nôtres, Monsieur Gélinas.
Thank you for being here, Mr. Jelinas. Mr. Wall, I'll start with you, Mr. Wall. After your years of experience at the SPVM, how big is the problem of repeat violent offenders who go through the justice system? I think it's important to talk about C-75, bail release in cases of repeat offense. When C-75 was adopted, I was a supervisor. I was a responsible officer with situations of domestic violence cases. I had to find out whether I had to release someone or detain them for them to appear in court later on. When the law was adopted, supervisors were trained on the principle of restraint. What we were told was that we had to make sure that people were released on bail under certain conditions to appear, and that detention was an exception. And this created commotion amongst police officers because we could take the chance of releasing criminals on the spot. We knew that there was a risk for the victims. People were accused of, victims of violence had to move to protect themselves. What I said in my preamble was that in cases of violent crimes and repeat offense, the law has to be tightened. We have to make sure that crimes against individuals involving people who are constantly released on bail and who constantly violate their bail conditions, those people should not be given the chance to go cause other victims. I don't want to interrupt you, but I don't have enough time. You know that with the introduction of Bill C-14 that was tabled in the House last week by the Minister of Justice, we are seeking to clarify loopholes that existed when it comes to clarity in C-75. Bail always has to do with the discretion of the judge. Do you agree with me that Bill C-14 will exactly respond to the concerns that we had with C-75. I read the bill. It is definitely an improvement, so it should be commended. But I think it doesn't go far enough because we are not codifying the number of repeat offenses. I believe that after a number of repeat offenses, for example, for crimes against women or against children or against seniors, it should be codified so that after 3-4 violations of conditions, that person should no longer be released on bail. Now, if you want to release someone who has violated their conditions 12 times, well, I don't have a problem with that. Neither does the police, because eventually that person will be arrested. But to constantly release people who are attacking vulnerable people, women, 10, 12, 15 times, we'll see 14 stop such behavior. I don't know. That's all. Mr. Fortin, you have 2.5 minutes. Thank you, Chair. Mr. Carrick, I would like to hear what you think about rehabilitation. In your opinion right now, are we able to rehabilitate people who are detained in our prisons, or is this an illusion when we talk about rehabilitation?
First off, I think rehabilitation is possible, and I think it should be a key component to an effective justice system. I am not a subject matter expertise on the rehabilitation programs that are being offered in correctional facilities, and a question better answered by those who are administering those programs. Suffice to say, they are important and they can work.
Merci.
Thank you. Right now, the criteria applied to release people on bail, I understand that for you, the issues for violent criminals, they should be detained and not released. Are there other criteria besides the types of crimes that should be taken into account? I have about 1 minute remaining, but I would like to know what you think. The criteria and the fact that right now, prisons are occupied by 72 of pre-trial detainees. So I would like to hear what you think about the conditions of bail release and preventive detention.
Bail should include both repeat and violent offenders, and we've got trends happening across this country with increase in property crimes, whether they be organized retail theft rings or otherwise fraud, crimes that are victimizing Canadians. So it should apply to repeat and violent offenders. The number of people incarcerated awaiting trial is not necessarily indicative of the bail process. It can also be indicative of a lack of deterrence in sentencing. You need to look at the two in concert, and we need to deter the crime in the first place, and when they are convicted, have strong enough sentences that we do not have repeats.
And surveillance. When someone is released on bail, do you think that those people are properly monitored?
Brief answer, Commissioner.
It depends on the circumstances and the situation.
Merci.
Thank you.
5 minutes, 5 minutes, Larry.
Thank you, Chair. Thank you, witnesses. Commissioner, for 4+ years, we have heard from premiers of every province. We've heard from police chiefs, presidents of police associations, mayors, victim advocacy groups, all asking the government to do their job. Keep Canadians safe and introduce appropriate bail legislation that is actually going to make a difference. I know that you must be deeply disappointed that C-48 has not had the desired impact. Our former Justice Minister claimed that they had delivered bail reform. The proof is in the pudding. Every day we wake up to one heartbreaking story after another of someone on bail committing carnage on our streets across Canada. So we are all hopeful that the government finally got the message with the introduction of Bill C-14. The title of Bill C-14 is called the Bail and Sentencing Reform Act. And to your point, sir, earlier you said there's been 80 changes to the criminal code. This bill is some 35 pages long, and there's hardly a mention of any sentencing reform. apart from talking about consecutive sentences for violent motor vehicle theft in the commission of a break-and-enter offense and extortion with arson. Apart from that, apart from making certain offenses an aggravating feature on sentencing, we have one sentencing reform. And I don't know if you caught it. It's embedded in this act, and wait for it. It's one of the most serious violent offenses in this country called contempt of court. I say that facetiously because this government wasted a precious opportunity. And I'll eventually be talking to the president of the Crown Association in BC, where his province is suffering an extreme rise in extortion. So here was an opportunity. What do you say to the government about these missing opportunities when important stakeholders have been giving advice to this government repeatedly for the last 4 years?
Thank you for that. Our commitment is to continue to work towards seeing further improvements in sentencing. This is not the changes that we were hoping for in totality as it relates to sentencing. And as in my previous comments, you have to look at it as a holistic system. If you don't fix sentencing, fixing bail is not going to be the complete solution. There needs to be deterrence, and that comes through appropriate sentencing, and there's more work to be done, and we're willing to assist with that work.
Turning matters over to Mr. Dalrymple, thank you so much for agreeing to testify today, sir. This has been a missing piece of the puzzle so far as part of our bail and sentencing study. We've heard from defense counsel, we've heard from academics, from law schools, etc., but we have yet to receive any input from Crown associations in this province. So I do thank you for your attendance. And I would agree with you, sir, that this is not a one-size-fits-all issue. We have to work together. All three levels of government have to work together to improve our criminal justice system. But from one Crown to another, I feel like I'm isolated in the House of Commons when I repeatedly describe the reality of being in the trenches day in and day out and hearing from politicians who think it's manna from heaven when the government introduces more and more reverse onus provisions to criminal charges. Can you provide some realistic thought on what really happens at a bail hearing when presented with a reverse onus or a Crown onus situation and the impact of the releases that we see in light of Bill C-75?
First, thank you, Mr. Brock, for your comments. As someone who has done bail, I can tell you every case, as you know, is very different. There's so many different factors dependent on the strength of the case, who the personality of the individuals in the court, and of course, the judge ultimately gets to make the final decision. Here's the thing. When the federal government passes new laws or makes new offenses, they're creating more work for frontline people. And if you're not prepared to make the investments on the front lines to drill down, go figure out how is this going to impact those prosecutors in the courtroom? Are they able to take on more and more cases? Are the police officers, do they have the resources to investigate more and more offenses and then for prosecutors to carry those through to court and prosecute them? If we don't have that investment, there's very little that may change. We can't urge you more than we need the federal government to step up and to support, frontline positions. And if that means, sending money to the provinces or ensuring that the provinces have the people to carry out and to enforce these laws, or when there are changes to the law that is going to spark a lot of litigation, as you're probably aware, we should expect that Defense Counsel may constitutionally challenge some of these changes.
Thank you, Mr. Dalrymple.
Ask yourself. Sorry.
Yeah, thanks. It's gone over. But
oh, I'm sorry.
Yep, it's all right. You'll probably have an opportunity later. We have time for another round if we keep things tight. Mr. Chang for 5 minutes.
Thank you, Chair. Commissioner, from your perspective, would you say that Bill C-14 demonstrates the federal government has listened to law enforcement and acted decisively to protect Canadians?
I would say that yes, C-14 indicates that the federal government has listened to law enforcement and is intending to act decisively. The proof will be in how quickly this legislation is enacted.
Thank you. You also mentioned that you are seeing more bail releases. Is it fair to say that that's exactly the gap Bill C-14 is designed to close by expanding reverse honors provisions and tightening bail for repeat violent offenders so that police will see fewer of those high-risk individuals released?
Sorry, can you repeat the question? I apologize.
Yeah, you also mentioned that you are seeing more bail releases. Is it fair to say that that's exactly the gap Bill C-14 is designed to close by expanding reverse honors provisions and tightening bail for repeat violent offenders so that police will see fewer of those high-risk individuals released?
Thank you for the question. Yes, I do believe that the intention is to reduce the number of high-risk offenders that are released and able to perpetrate further harm into communities. That should be the intention of any effective bail process.
Thank you. And would you urge all parties to support Bill C-14, and why?
I would urge all parties to work together to enact the necessary legislation to address the deficiencies in bail and sentencing, and C-14 is a really good start, but there needs to be more if we're going to be truly effective.
Thank you. And my next question goes to Mr. Rivard. Your organization focuses on trauma-informed practices. How can these principles complement stronger bail and sentencing measures like those in Bill C-14?
Thank you for the question, MP Chang. I was intently listening to the entry point of how decisions are made through the court systems and how our organization can help is around what data is collected to determine risk and provide that to Crown so that they have a more broad view of somebody on a pathway to violence and understand the multiple pathways to violence that somebody's engaged in. And again, understanding that, yes, history of violence is an important indicator to determine dangerousness, for example. But at the same time, in our work post-Columbine, post-school shootings, Tabor, Alberta, for example, we do understand that some people are dangerous and have no histories of violence. And so our information, our trainings are all about helping Crowns and judges make better informed decisions and actually trauma-informed decisions if need be. But the safety of community has to be first, 100%.
Thank you. And how can the federal government and the provincial government work together to make sure that more people in the justice system have access to trauma-informed supports?
Well, I think that comes down to your continued support through Public Safety Canada and ensuring that the multiple partners continue providing some really fundamental training and assisting people to collectively, again, I keep saying collectively, determine risk and assess risk for individuals on pathways to violence.
And how would you see trauma-informed practices helping to reduce repeat offending and improve community safety over the long term?
Well, one of the things that occurs with offenders is they become traumatized by their own acts of violence at times. And of course, they need to be accountable to that no matter what. But some understanding of that, and there was conversation by the panel around rehabilitation and understanding rehab. There's a lot of insights that can be provided if we understand that, because they may not be in jail forever, and that's where community can play a big play in assisting our police officers.
Thank you.
We've come to the end of the second round. So for the third round, we'll get everyone in, the five questions. I'll just cut everyone by 20%. So everyone that had 5 minutes will have 4 minutes, and then Monsieur Fortin, vous aurez 2 minutes au lieu de 2 minutes et demie. C'est juste dans les...
Mr. Fortin will have 2 minutes instead of 2.5 minutes, so we'll be able to go until 6:30.
Opportunity to question. I have Mr. Gill for 4, then Jamie Maloney, Réal Fortin, Roman again for 4 minutes, and Jamie again. Thank you.
Thank you, Chair. Thank you, everyone, for coming today. And my question to Mr. Dalrymple, communities like Brampton and across Canada are seeing repeat violent offenders released from prosecutors can even finish paperwork. Doesn't that show the system is failing every level?
Thank you, Mr. Gill, for your question. The system is not properly funded to support the objectives of the legislatures. We need more resources. We need to ensure that we keep the ratio of accused to prosecutors low. There needs to be some guidance on that issue from the federal government. Simply to pass new laws without ensuring the resources to carry out the laws so that prosecutors can make quality submissions to a court to persuade a judge to see it from their perspective and from the public interest perspective is critical. So it is not simply enough to change a law. You need to make sure that the downstream resources are present to have the desired impact.
Do you believe this Liberal government has done enough to ensure that Crown offices have the tools and staff they need to enforce meaningful bail reforms?
It is the responsibility, of course, of the provincial governments to ensure that their provincial prosecution services are properly supported, properly staffed by prosecutors, support staff, as well as having adequate technology to carry out prosecutions in the public interest. If there needs to be funding, it needs to come from a level of government. Of course, it appears that it should come from the provincial level of government. However, as we know, the federal government tends to have significant more resources to deal with these matters.
So my next question, the Liberal seems content to blame provinces and courts for bail breakdowns. From where you sit, is this a leadership problem in Ottawa, a refusal to give prosecutors the tool and resources they need to keep people safe?
We question how helpful it is for different levels of government to blame other levels of government. The objective is clear. We want to uphold the rule of law and to protect Canadians, law-abiding Canadians. To do that, the governments need to work together. And they need to think through the whole process, as we've said, holistically, to ensure that it is properly resourced from beginning to end. And if a level of government is going to take the lead on reform, they certainly need to coordinate with the provincial and, to an extent, municipal level of government to ensure that the desired impact will be achieved. And you need to make sure that you have the resources to do it.
Okay. My question to Commissioner now. Commissioner, you have testified that violent offenders committing crimes while out on bail are not rare. Yet after years of Liberal promises, nothing has changed. How many more tragedies do we need before this government acts?
I don't know that I can answer that question, sir. I'm hoping the time to act is now, as I've previously stated.
In Brampton, violent crime involving offenders already on bail is becoming an almost weekly headline. When you see this pattern repeated across the country, does it confirm what policing leaders have warned, that Liberal bail policies have made Canada less safe?
Just a brief answer, Mr. Commissioner.
I can't say that bail policies exclusively have made Canadians less safe. They certainly have contributed to the current state of concern over public safety, and there are a number of other factors, including how we're dealing with drugs in our communities, organized crime, lawful access. There is a whole list of things that we need to turn our attention to.
Thank you. Thank you both. Mr. Maloney for 4 minutes.
Thanks, Chair. Mr. Dalrymple, I'm going to pick up with you again. The Conservatives constantly accuse us of trying to blame the province. I'm not going to provide a civics lesson here. I'm just going to highlight what you've already said. Is each level of government is constitutionally bound by the responsibilities that are set out. We're responsible for passing the laws. We do not administer the justice system in British Columbia, Alberta, or any other province. So it's not a case of blame. So we can pass these laws, and it goes back to what you and I talked about before, about overburdening a system that's under-resourced. But I do want to pick up on something you just said. You said the feds seem to have more resources. That frightens me, frankly, because people like to blame the federal government on the one hand. Provinces get very, very upset when we try to enter into their jurisdiction, but they're happy to take our money. How does it become a federal responsibility, in your opinion, if the system is under-resourced at the provincial level?
Well, ultimately, this is a collaborative effort. I will leave it to the politicians to decide how they're going to make it work and to achieve the outcome that we desire. One example I would like to put forward is what we've been calling for is a National Bail Information Repository or system. As you probably know, across the country, there is a patchwork of different bail information systems that our prosecutors are using. As someone who has practiced on the front lines, I can attest to how difficult it can be to get information on warrants, outstanding orders, and conditions of court when someone is moving across the country, like many offenders do. Having the federal government take the lead on something like that may be of great utility.
That's helpful, and I agree with you completely. But in terms of provincial responsibility, again, I'll use the Ontario example. We've been asking the province for data sets for some time now, and we're having trouble getting it. Be that as it may, I'm going to switch over to the morale issue that we talked a little bit about before. One of the problems with this entire discussion is that there's a lot of rhetoric being thrown around at all levels, and nobody's immune from blame on that. Earlier today, we had testimony from a witness from the Ontario Police Association who said, let's get this bill passed immediately. No politics, no stunts, no political stunts. We've seen time and time again politicians amp up the rhetoric, using slogans like jail, not bail. I've seen politicians go on television after a crime's been committed and talk about the failure of the bail system before the person's even been apprehended or before they even know who committed the crime. So maybe I'll ask this to you, Commissioner Carrick, because I have serious concern. I'm worried about the morale issue as much as you are, but does it concern you that politicians take this type of approach when they're talking about an issue that's so important?
What concerns me is we're not leveraging the opportunity to work collaboratively as much as we should be. I highly doubt that there's anyone in this room that is more concerned about the morale of my police officers than I am. And this is an opportunity that we can address that through responsible decision-making that prioritizes public safety over partisan policy. This is a rare opportunity, and I'm hoping that we will see it leveraged.
I will end with this by just simply saying I couldn't agree with you more, and I hope that your appeal lands with everybody listening today and beyond, and that we can get this bill passed quickly and move this issue forward. Thank you.
Thank you, Réal. Un petit 2 minutes.
Merci, Monsieur le Président.
Thank you, Chair. Mr. Gelina, my question goes to you. Right now, we know that our prisons are full. Very often, we are told that there are many people who have to be turned back to go home before they come back because the prisons are overloaded. I understand that we need to tighten bail conditions and not release just anyone on bail. My question is, at this point, should we think about investing more in rehabilitation, education, prevention through our community organizations, schools, and so on? Or should we invest in building more prisons or extending our prisons to detain more prisoners? In your opinion, what should we be investing our money and energy on? I think it's everywhere because, once again, we cannot eliminate prevention. We must make sure that people do not find themselves on the wrong end of the law, but it takes resources either to keep them behind bars. But what concerns me is that there's no possibility for social integration. We hear that sometimes during provincial sentences. it's a revolving door. There are no programs. There are no rehabilitation programs, not in the provinces. Thank you for being here. I would have loved us to continue this conversation, but we don't have enough time. Thank you.
Mr. Baber, followed by Mr. Maloney, 4 minutes each.
Thank you. Commissioner, we heard from you earlier on that, regretfully, the Liberal legislation does not address parole. A violent or repeat offender would be eligible for parole after a third of their sentence. What do you think about that?
I think that's another area of legislation and process that absolutely needs to be revisited. We run a very successful repeat offender parole enforcement program. I am seeing the numbers of arrests go up year after year after year after year, and these are some of the most dangerous offenders in our communities. So we would welcome the opportunity to participate in any review of the parole process.
Commissioner, we've been holding these hearings for a number of weeks now, and almost every panel includes a witness that expresses considerable concern with respect to the prevalence of young offenders in recent years, and in particular, their involvement in gangs and violent crime. And as my colleague, Shadow Minister Brock mentioned, the bill does not deal with sentencing nearly as enough as it should, but I was astonished to see that it does nothing to address sentencing for young offenders. Is that something that disappoints yourself in your capacity as chief of police associations around the country?
I do believe it does address one component for sentencing of young offenders where there has been violence used in the commission of an offense, but we're still reviewing the legislation. I do believe there needs to be greater attention on young offenders, and I have heard previous testimony over the motivation to engage young offenders is the lack of sentencing. That is part of it. There's very little deterrence to a young offender, but what is at the heart of this is the amount of money that young offenders are offered by criminal networks and criminal organizations, from $5,000 upwards to $100,000, depending on the seriousness of the crime. And this is all done electronically using secure apps, and we need the lawful access legislation to get in to refute that, to combat that, and that's where we're going to make some real progress in this particular area, is take the profit out of the crime and stop criminal organizations from victimizing young people.
I appreciate that, Commissioner. And finally, one of the big fails of Liberal Bill C-75 is that it created a diversionary framework for offenses involving failure to comply with court orders. So offenses such as failure to appear, breach of an undertaking, even breach of bail may go unpunished. And that is because basically Bill C-75 allows the Crowns to divert some of these cases, and they often do because they're busy or for other reasons. Are you disappointed that this diversionary framework has not been addressed by Bill C-14?
There is an opportunity and an obligation to look at that diversionary framework. Let's go back to the three primary principles of bail. One of them is maintaining confidence in the judicial system. And if we continue to treat fail to comply or fail to appear charges as administrative charges, we are negatively impacting the reputation of our justice system.
By not prosecuting or by diverting such offenses of failure to comply with a court order, in my view, respectfully, we're undermining the rule of law.
We are when we do not. We are when we do not take these offenses seriously.
Perhaps the Crown prosecutor can take that question in British Columbia. What do you think about the diversionary powers?
Very briefly,
Diversionary powers.
For,
as briefly as you can, because we're up.
For failure to comply with court orders.
Yes, of course, those are policies set by the governments. The provinces, I understand, have set that. Of course, we follow whatever the policies are of the provincial government and the laws of the land. So we will enforce whatever our legislators decide is appropriate.
Thank you. And Ms. Latanzio instead of Mr. Maloney this time.
Thank you, Mr. Chair. Donc, je vais adresser ma question à Monsieur G.
My question goes to Mr. Jelinas. Do you believe that the measures proposed in Bill C-14, like expanding reverse onerous provisions, tightening conditions imposed on violent offenders will help resolve the operational challenges on the ground. As I said a while ago, it's a step in the right direction. What we need to understand is that we need to conserve consideration of the justice system. Fear of Canadians. Let's know that people accused of violent crimes using firearms, crimes by organized crime networks targeting vulnerable people, those people should not find themselves on the streets, or if ever they are released, we make sure that they respect their bail conditions. At the same time, when there's any breach of bail conditions, we should see this as an affront to the justice system. These people are undermining our justice system and should therefore not be released. So the role of the federal government with this legislation, including C-14, is just part of the solution. In your opinion, what important measures should be taken for Quebec and other provinces to align their practices to the legislation? As I said, the administration of justice lies mostly with the provinces. If we don't have laws adopted by the federal government, there's not much we can do. Of course, the Crown Prosecutor said this: we must allow time and give resources to the provinces to study files and allow judges the time and resources to deal with the cases, because sometimes a number of people are represented by many lawyers. Why, in your opinion, what measures should be taken for more severe sentences as provided for in C-14 to ensure the safety of our communities? Once again, as I said, anything that has to do with vulnerable people, organized crimes, violence, firearms, these are all cases where claimants should be exceptional. We must make sure that these people are detained, because most often we stay in touch with we know the criminals. The criminals say they're going to be released by their lawyers, and sometimes they are very proud of that. So, and with the mandatory minimum sentences, these people say there are going to be no minimum sentences, so they're going to be released. So what is the role of prevention? It is essential. It's like an RESP. We are not going to reap the fruits in the short term, but we need mechanisms that help us assess effectiveness, but it's for the long term. Whether it be community prevention measures or other preventive measures, we must allow police officers the resources to arrest people and to do their job, because prevention is not simply distribution of gifts, but making sure that police officers have the resources they need to do their work and to go down on the ground. Also, work that is being done in collaboration with police stations and community services on the ground. What do you think about that? I think it's a good thing. We must believe in that, because the solution does not only lie with the courts, the police stations, or community services. It requires collaboration. There have been failures in all the systems, the school system, the justice system, and so on. So what is necessary is collaboration. Thank you. Thank you. It's now 6:30 p.m. I would like to thank the witnesses for this very interesting testimony, which will help us in our deliberations.
Of things for the committee. So on that, I will. We'll see you on Thursday. Yep. Bye bye.